refresh once. Refresh. I did this. Come on. You can. Hey,
Hello, welcome everyone to the 13th edition of our Shastrartha series, where we are looking into the DPDP Act and the draft DPDP rules, which have been published for consultation on the 3rd of January 2025. The DPDP Act itself has wide-ranging implications for financial sector entities. In this session, our focus is on the draft rules
Recording in progress.
along with relevant portions of the Act and how they would impact lenders, especially in the digital lending space. Here with me are my colleagues, Achishman and Aditya from our legal team, and the three of us here will break down the implications of these rules for lenders and highlight important aspects of this rule. As we start, can Achishman give us a flavor of the DPDP Act in the context of the newly published rules?
Yeah, thanks, Subhajit, for the introduction. The concept of privacy as a fundamental right was upheld in the landmark judgment of K.S. Puttuswamy versus Union of India judgment, which is also popularly recognized as the Aadhaar judgment. This decision laid the foundation for a series of legislative developments that ultimately culminated in the enactment of the Digital Personal Data Protection Act, or the DPDP. The DPDP is a comprehensive piece of legislation that addresses privacy holistically, establishing robust frameworks for the collection, processing, and protection of personal data. The Act defines personal data as any data that can directly or indirectly identify an individual. Additionally, the DPDP introduces key terminologies to clarify roles and responsibilities within the data ecosystem. For our discussion, pertinently, three terms will be material: the data fiduciary, the data processor, and the data principal. So the data fiduciary is an entity that determines the purpose and means of processing of personal data. So in case of lenders, this will usually be the lenders itself. As in the data principals, it refers to the borrowers, that is the individuals to whom the personal data pertains, and the data processor is an entity that processes personal data on behalf of a data fiduciary. Usually this will entail the lending service provider. Further, the DPDP also emphasizes consent as a fundamental basis for the lawful processing of personal data. It stipulates that consent must be informed, specific, and unambiguous, with clear options for withdrawal provided to the data principal. The Act also empowers data principals with a range of rights, such as the right to access, correct, and erase their personal data, along with a right of grievance redressal. Data fiduciaries, as in the lenders, are obligated further to implement reasonable security safeguards, comply with prescribed data processing standards, and ensure transparency in their operations. Additionally, they also are required to promptly report personal data breaches and facilitate grievance redressal mechanisms. This act is further supplemented by detailed rules that outline procedural and technical requirements, including the format and content of notices required for obtaining a valid consent, standards and obligations for consent managers to ensure smooth facilitation of consent management, protocols for reporting personal data breaches, including timelines and information to be disclosed, as well and guidelines for implementing reasonable security safeguards to protect personal data from unauthorized access, destruction, or disclosure. That summarizes from the view of the DPDP Act and the rules. I would like my colleague Aditya if he would like to add anything to this discussion on this point.
Shishman, I really do think you give a very comprehensive background of the genesis of the Act. But I think one thing I would like to clarify for our audience going forward in the session would be what they can really expect from this. It would be, I think, a little unrealistic or maybe even presumptuous to assume that we can unpack all the DPDP rules and Act and their implications for lenders in this session, which may not be possible due to paucity of time. But what we can certainly do, and I think what we will do in this session, is give them the necessary context and tools to navigate this new regime. Because what is happening and what has happened, or rather will happen once the rules are effectuated, is that there's going to be a paradigm shift in how we are observing compliances, and how like our approach to the entire compliance framework is. It's going to go from checkbox compliances, which is really like doing the procedural bare minimum, to something that's substantively a lot deeper.
But Aditya, just to interrupt you there, Aditya, my understanding is that there are a number of regulations already there with respect to privacy, as you said, borrower consent, technology standards in the regulated lending space, and especially when it comes to financial or IT services outsourcing. Assuming lenders are already complying with these rules, why would an understanding of, or, I mean, they're already complying with these regulations, why would an understanding of these rules be crucial for lenders?
Now, I would like my colleague Shishman had recently just stated, it is, I think, very important for us to highlight that the concept of privacy itself is not new to the regulated lending space, and particularly for fintech entities. Now, the RBI has consistently emphasized the importance of data protection and security, and Shubhojit, like you said, to the digital lending guidelines or IT outsourcing, IT governance, and to some extent, even through financial services outsourcing. These regulatory measures do mandate compliance, and they do have sort of robust system requirements to ensure that data remains safe and secure. But I would really like to answer your question in two parts because it's very important for our audience here, a bulk of whom are lenders and a bulk of the audience who are going to be watching this recorded session. So firstly, why is it material for lenders? All the parties in a digital lending journey are implicated by these rules. From the borrower to the lender, and even third parties that the lender contracts with, third party service providers that the lender contracts with. The borrower is very obviously our data principal. The lender is very clearly our data fiduciary. And the third parties, such as DLAs or other service providers, DSAs, DMAs, can either be data processors or in certain cases also data fiduciaries in their own right. That is actually a nuanced conversation. We may develop resources on it in the future, but for now it suffices to say that every single party in the digital lending journey is implicated by these rules. Now, the entire business of digital lending, I would say from cradle to grave, runs on the use of personal data, right? Whether we are talking about the loan sanction process, which will entail KYC and underwriting, or else also cross-selling and cross-marketing, which for the uninitiated, cross-selling, I'm certain many of audience members would know, but cross-marketing is also when we use the borrower's personal data to market them relevant products. One very common practice, for instance, is if the borrower or the potential borrower has a property in a very posh and upmarket area, that data can be used either by the lender or by a third party to market them a loan against property. So things like this, the entire life cycle of the digital lending process runs on the use of personal data. So it is, I think, very pertinent for lenders to understand these rules. The second aspect is, right, you are right, there are other regulations in the fintech space. But the key difference, so like I said, paradigm shift. The very key difference is that Other regulations tell us what to do. Digital lending guidelines tells you that you have to obtain borrower's consent, but they do not tell you how you should do it. And this is a big shift, because when you are told only what to do, you can perhaps, it may be feasible to adopt a checkbox or tick box compliance method. But now that you're also being told how to do it, it would require a lot of process changes from the side of the regulated entity, and also redrafting of the loan documents, in certain cases creating institutional frameworks, which I think we'll get into in this session.
So, Aditya, in the light of this, given that you say the rules tell us how to do things, can you give us an outline of the rules and the ones that are most relevant for lenders, the ones they should be looking out for?
Most relevant for lenders, I would like to maybe preface and give a context that when Archishman and I would be talking about aspects most relevant or pertinent for lenders, we certainly don't mean to imply that other aspects are not relevant or pertinent for lenders. But these aspects that we will touch on today, and then I'm going to list actually right now, are the ones that from an operational standpoint require immediate attention, because they would actually entail a lot of work, a lot of process changes from the lender's perspective. So I can actually list these down. The first, of course, is a notice of use of personal data, then the reasonable security safeguards, the intimation of the personal data breach, the time period for the specified purpose to be deemed as no longer being served, the rights of the data principals, and finally, processing of personal data outside India. For some of our audience members, as well as people watching this recorded session live, we do actually have a write up that our team has very recently published. We also go over the penalties as applicable for non compliance with each of these rules. After this session, if you're interested, you can also take a look at the write-up and come to us with any questions you may have. Our team would be very happy to help you out with the same. But
Sure,
Shubho,
Aditya.
before
But
we start with your
first,
question,
first things first, though, Aditya, in the lending journey, what would be personal data regulated by the DPDP Act, the Act and the rules? Maybe this question is to Achishman. So,
So
Achishman, would you tell us what personal data actually entails in the lending journey?
Yes, Subhojit, surely. So, like rightly clarified by my colleague Aditya, so in a digital lending journey, or rather lending journey, the lender processes a lot of personal data of the borrowers or prospective borrowers. This can be discussed in stages like pre-onboarding documents, KYC information, credit underwriting, post and processing of data, post opening. Let's break down in parts. Like in case of pre-onboarding documents, like in loan application form, the lender, the borrower will usually provide its name, phone number, email ID, etc. These are personal data. In respect of KYC aspects, certain lenders were permitted may collect Aadhaar number, details contained in Marks Aadhaar, OVD details, PAN number, and other KYC documents. Also, as I mentioned in the KYC master direction. So, for the purposes of credit underwriting, which is a very essential part of the lending journey for determining whether a loan should be provided to a borrower or not, usually the lenders collect information from CICs like the credit information report, credit score, as well as the information that is provided by the borrowers, like that of bank account statement, Form 16, etc. Post opening of a loan account, specifically for a lender who has sanctioned the loan account number, the UCIC number that is a requirement of on a KYC level is also a personal data of the borrower itself. Now, moving this aspect from the lenders, it is also pertinent to discuss upon the requirement, the personal data processed by a digital lending application. Usually, in a digital lending applications, a DLA offers a customer interface, where usually the services that are going to be provided, that is matching a borrower with the lender, is usually behind a login screen. So, for the purposes of login, information like that of name, email ID, phone number, as well as login passwords are required to be set up by the borrower, and these are also personal data of the borrowers.
Okay, got it, Achishman. So, moving on, Achishman, to the processing of personal data. So, when is there a need to give consent for the processing of personal data? My understanding is that the Act also talks about something called legitimate use. Can you help us understand what could come under legitimate use, specifically in the context of lending?
So, prior moving on to the discussion of legitimate use, as has been rightly pointed by you, Shubhoji, there are basically two purposes of processing, two ways by which personal data can be processed. That is processing based on consent and processing based on legitimate uses. So, where processing is based on consent, there is a requirement to provide a notice, and through that notice, a consent has to be obtained from the data principal or as in we know, the borrower. However, where processing is based on legitimate uses, the same is not required. As regards the modality of obtaining consent, Section 5 of the DPDPA provides that consent would be obtained by providing a notice to the data principal, as has been also reiterating as I stated above. So what is actually to be captured in the notice and how it should be framed has actually been provided under the rules. So Rule 3 discusses upon this. So now let's explore what is provided under the Rule 3 itself. So Rule 3 of the DPDP rules provides that the consent needs to be provided independently of any other information that has been, is, or may be available to a data fiduciary. So it comes out very clearly that here the notice cannot be buried into a mountain of other consents or hidden away in the clauses of loan agreement MITC or the loan application form itself. The consent, the notice itself needs to stand out as a separate and an independent document. Having understood the first requirement, let's move on to the second requirement, which states that the notice should be provided in a clean and plain language. As per Rule 3, such notice should be provided should provide an itemized description of personal data and purpose for which the information is being collected and the services that will be provided in respect of collection of the information. Let's understand this step by step. So the itemized description and purpose norms here would necessitate that each personal data that will be collected by the lender is listed out, and against it the purpose of processing is provided upfront to the data principal so that the consent of the data principal can be obtained. For example, in case the lender cross sells certain products like that of insurance with the loan itself, the data fiduciary in its notice should clearly list down the information that will be used for the purpose of cross selling, and aside it should also state that this information would be used for the purpose of cross-selling of insurance products. Now, having discussed notice-based consents, perhaps my colleague Aditya could discuss upon what the concept of legitimate use is under the Act and whether the rules provide anything towards this aspect.
Right, Archishman. So, in this regard, I think some context would really, really help our audience members. Legitimate use is captured under Section 7 of the DPDPA, right? And now, for paucity of time, we can walk through just one subsection. Now, under subsection 7A, for instance, processing of personal data without consent is permitted when the data subject voluntarily provides the data for a specific purpose. This provision exempts the need for a separate or additional notice. And in our view, the example I think that is being one of the examples that is very much being discussed in the industry right now. But in our view, for instance, when a borrower fills out a loan application and submits KYC documents to a lender, you can take a view that it is deemed as voluntarily providing personal data for processing related to loan sanctioning and servicing. However, I think as made very abundantly clear by the illustration in the Act itself, different norms may apply in the case of VSIP. So that is something that you would really have to look into. Again, it is with the Act, with the rules, and for fintech entities especially, everything has to be read with the other extant fintech regulation. These things cannot be seen in isolation at all. So with this specific aspect, you have to read it with the DL guidelines. There, an exception arises in the case of digital lending, and paragraph 10.1 of the digital lending guidelines mandates prior explicit consent for collecting borrower data. Now, this mandate of prior explicit consent is actually a blanket mandate, and you can see that it doesn't contain the exceptions under the DPDPA. In such cases, the defense, or rather the exception, I think that's a better word, of voluntary provision under Section 7A may not apply, and there would still be a need to obtain explicit consent. So I hope this gives does this give the background that you were looking for?
Yes, it is. I have a question with regards to explicit consent. So, Section 5 of the DPDPA also states that the notice of consent has to be provided in a manner in which the DP can exercise her rights under the Act. I understand that the rules prescribes the mode by which this can be ensured by lenders. Chishma, could you shed some light on this maybe?
Yes, Shubhajit. So you are absolutely right. Rule 3.3 provides the manner in which the requirement of Section 5 is to be complied with. Rule 3.3 states that the notice for acquiring consent should also provide communication link to the data principal for accessing the website or app through which the DP can withdraw her consent as well as exercise her rights under the Act. Ideally, in case of digital lending, this option can be provided by can be integrated in the DLA itself. And in cases of physical lending, in our view, this may be done through the GRO by raising such a request with the GRO, Grievance Redressal Officer of the lender.
Does the rule only prescribe this link for withdrawal of consent being provided in the notice itself, considering that a similar right is also available for voluntary consent under Section 7A, which does not require a notice to get consent? Is that understanding correct?
Yes, it is correct that the Act only requires that the notice should contain the link to website or app through which a DP can exercise a right of withdrawal. However, Section 12 of the DPDP Act grants this right to data principals also who have voluntarily provided their personal data. While notice-based consent may not always be mandatory in such cases, lenders should ideally include a provision in the loan application form itself, directing the customers to this link on the website through which the data principal can exercise their right, including the right of withdrawal.
So I think so far, Aditya, Achishman, we have given clarity on the notice-related requirements, right? So we have covered so far the notice-related requirements, the requirement to collect consent, the requirement, I mean, the exception of legitimate use. So now moving on slightly, um, both Achishman and Aditya, both of you, you had also highlighted the rights of the borrower, right? Including the right of withdrawal. So, in this context, can you clarify whether the DPDP rules specify any specific mechanism that the lenders must follow to establish a system for facilitating the borrower or customer to exercise such a right? Both Achishman and
Sorry, I'm so sorry. Please go on.
no. So, what I was saying is, in this context, could you clarify whether the DPDP rules prescribe any specific mechanism that the lender must follow to establish a system for facilitating the borrower or customer to exercise such a right, the right of withdrawal?
Okay.
So, Aditya, maybe you can take this question.
Right. Now, Rule 13 does outline operational aspects pertaining to the exercise of the data principal's rights by the data principal. The following requirements are specified for websites or apps. Um, One, they must detail the procedure for the data principal to raise a request for exercising their rights. And second, they should also specify the particulars, such as a username or other identifiers required to identify the data principal under the terms of service. Now, this there is actually a lot to unpack here, in my opinion at least. So this discussion regarding these requirements can be approached in two parts. One is the procedural detail, and the second is pertaining to verification of the data principal. As regards procedural details, the link provided in the notice or loan application form should direct the borrowers to the appropriate section of the lender's website or the app. Ideally, this should either do one of two things: A, redirect the borrower directly to a portal where the request can be raised, or else guide the borrower to the mechanism for exercising the rights. Now, again, in my view, aside from the right of withdrawal, the DLA or the app could also actually provide the contact details of a designated person to whom the request for exercising rights can be directed. The role can be effectively managed by the lender's GRO. I think this is something that Archishman mentioned a few minutes ago. However, for larger data fiduciaries, additional resources or actually a dedicated team may be needed to handle such requests efficiently. It would all depend on the existing infrastructure. Furthermore, as outlined under Rule 9, every response to a communication regarding the exercise of a data principal's rights under the Act must also include the business contact information of the data protection officer. This is, of course, in the case of significant data fiduciaries who have not been notified yet, or another designated individual who can address such requests on behalf of the data fiduciary. These contact details must also be made available on the data fiduciary's website or the app, or actually both as applicable. Now, I mentioned that there were two aspects. The second aspect to consider is with regards to verification of the data principal. This procedure should outline the minimum documentation or information required to identify the data principal. Now, for borrowers who have already been sanctioned loans, identification can be done through one of two ways. Either there is a request raised through the email address or the mobile number that the borrower had themselves provided during the loan application process, or else B, additional details such as the LAN stand for loan account number, or other unique identifiers. This is, of course, one perspective. Now, in the case of digital lending, there is actually another perspective that you could take, which is that lenders may not need to rely on external identifiers, because in the case of digital lending journey, it's happening through app-based registration, right? So instead, you could actually have app-based features which are designed to allow the borrower to directly raise requests to their accounts, ensuring quite an integrated and efficient process for exercising their rights. So just there is actually one more thing I would like to add here, because in respect of the internal documentation, it's also important to state that the lender's policies and their own SOPs, their own standard operating procedures, should actually also provide clear timelines within which such requests raised by the data principal are required to be addressed by the concerned persons in the lender's team. So
Right,
this
Aditya.
was right.
Right. While we are on this topic, we should also explore the right of erasure. So, which is provided to the data principal. The Act outlines two ways where this right to erasure becomes effective. One is where the request of withdrawal is raised by the borrower, and number two is when the specified purpose is no longer deemed to be served. Right. So, in the latter case, has the lawmaker provided any timeline within which the data is required to be deleted?
I would like to take up this question. So, Section 8(7) of the DPDPA provides the requirements when a data is required to be deleted. So, one of the circumstances where the deletion is required, as has been rightly pointed out by Shubhoji, where the purpose is no longer deemed to be served. So in such cases, the DPDP rules, Rule 8 stipulates that the data fiduciary is required to delete the data within a period of 3 years in case where the data fiduciary is an e-commerce entity, a gaming intermediary, or a social media intermediary, unless obviously the retention is provided under applicable laws or regulation. Further, the rule also draws another compliance aspect, which states that a notice of 48 hours is also required to be provided to the data principal, stating that unless the data principal logins into her user account or contacts the data fiduciary for the purposes for the specified purpose for which the consent was provided or voluntarily provided, the personal data of the data principal would be completely deleted.
Right. Given that Achishwan, you mentioned that the rule has specified e-commerce entity, gaming, and social media intermediaries. Uh, in your view, maybe Aditya can take this up. In your view, Aditya, does this rule have any impact on lenders?
Lenders themselves may not be directly impacted by this rule. However, the rule actually could have significant implications for DLAs, which are for some of our audience members, digital lending apps that host multiple lenders, right? Let's say there's an app that provides a matchmaking service between the borrower and the lender, as well as peer-to-peer lending platforms. Because in the case of P2P platforms, NBFC P2Ps, they in a sense act as intermediaries between the borrower and the lender. So I think to justify this position, attention must be drawn to the definition of an e-commerce entity under Schedule 7 of the rules, which describe it as any person who owns, operates, or manages a digital facility or a platform for e-commerce as defined in the Consumer Protection Act, but excludes a seller offering their goods or services on a marketplace e-commerce entity as defined in the said act. Right? With this definition of what an e-commerce entity is, we can clearly see that marketplace e-commerce entities, such as P2P platforms and DLAs, which facilitate the matching between the borrowers and the lenders, sometimes maybe on basis of rule-based engine or any other criteria, are likely to fall under this definition. As a result, these platforms will be required to comply with the data deletion norms outlined in the rules. However, I think it should also be noted that this requirement towards deletion of data, rather than noted, it's actually very pertinent to state that this requirement towards deletion of data is only applicable if the DLA or the P2P platform has more than 2 crore registered users in India. Interestingly, our team has also in the past developed resources pertaining to what to marketplace lending and to marketplace entities. If any audience members are interested, you can find the same on our website. But I think, Shubhajit, for our purposes, does this answer your question?
Yeah, it does answer my question. And this 2 crores, the number of 2 crores is quite a large number when it comes to DLS, digital lending applications and platforms or P2P platforms. I am not sure whether these platforms see a scale of this nature. So this data erasers, the specific guidance with respect to data eraser, this time period of 3 years, I am not sure would be applicable to the existing or the current platforms that are there. So having wrapped that up, we can move on to Rule 13. In Rule 13, what is evident in my view is that the exercise of rights by the DP primarily constitutes service requests, right? Rather than grievances related to processing of personal data. These rights focus on enabling DPs to control their data rather than addressing dissatisfaction or complaints. And however, under Section 8, subsection 10 of the Act, lenders as data fiduciaries are required to establish grievance redressal mechanism to address any complaints or grievances from borrowers. This raises a couple of very important questions. Do, do the DPDP rules specify the requirement for such grievance redressal mechanism? Additionally, are there defined timelines within which the grievances must be resolved? Lachishman, would you like to take this up?
Yeah, sure. So, Rule 13.3 of the DPDP rules does provide that the lender, in its role as a data fiduciary, is required to publish on its website or app or both, if it is applicable, the period within which the grievances raised by the borrower will require to be responded to. Further, Rule 13.3 also states that for the purpose of ensuring the effectiveness of the system, the lender is required to implement appropriate technical and organizational measures. However, it may be significant to note that the term respond has been used instead of the term redressal of grievances. In such context, whether the term respond would be treated as acknowledgement of the grievance, or actually addressing the grievance is unclear. Further, in circumstances, the same means redressal of the grievances, the time period of redressal has been required to be set up by the data fiduciary. Unlike in some of the customer beneficial legislations like that of Consumer Protection Act, which prescribes a 30-day timeline to address the grievances raised by the borrower.
In summary, do we understand that the Act contains provisions stating that the DF is required to have a grievance redressal system, and the rules essentially provide towards the DF publishing the period within which the grievance will have to be attended to, right? In in case we assume that the term response actually means responding to the grievance and not the redressal, do you feel that the lack of an actual timeline being provided under the rules and the Act might have an adverse effect upon the fundamental rights of the borrowers?
So, Subhojit, to address your question, it should be noted, as has been also rightly pointed out by my colleague Aditya earlier also, that RBI has consistently emphasized the importance of maintaining the confidentiality as well as the integrity of the borrower data. This has been done through various master direction notification circulars like that of Fair Practice Code, IT Master Direction, IT Outsourcing Directions, and some part of financial outsourcing directions as well. Additionally, it should be noted that there is a term known as banker secrecy obligation that requires banks as well as lenders to keep client details confidential, as well as implement technological standards to protect this data. In my view, ideally, these grievances related to the obligation arising out of these personal data things should ideally be categorized as a lending specific grievance. And under the RBI norms, all lending specific grievances are required to be addressed within a period of 30 days from its receipt. In light of these provisions, I do not feel the absence of the grievance redressal timelines being provided under DPDP rules or the Act itself poses any adverse impact, as the lenders will still be obligated to redress the grievances within a 30 days timeline, provided that or unless the lenders have chosen a shorter timeline in alignment with the DPDP Act and the rules.
But I want to focus on this 30-day timeline that you are stating. So, what will be the consequence if the lender fails to address the grievance or respond to the borrower within this 30-day timelines? Do the rules themselves prescribe anything towards this?
Shubhajit, the rules do not actually prescribe anything upon the failure of the lender to address the grievances within 30 days timeline. However, attention should be drawn to Section 13.3 of the Act, which states that in case the borrowers are unable to get their grievances redressed within the stipulated timeline set by the data fiduciary, they would have a right to approach the data protection board itself with their grievances. Further,
Mhm.
as has been also stated in the previous question, this is actually lending specific grievance. So the 30 days timeline either way applies, and the RBI ombudsman in such cases would have the appropriate jurisdiction to address those grievances under the appropriate RBI norms.
So, staying on this topic of grievance redressal, and my question now is to Aditya. I mean, do you think the existing GRO, the grievance redressal officer, so we already in the case of digital lending, we know that digital lenders need to appoint a GRO, right? We also know that in case certain outsourcing cases, there should be recourse of the borrowers directly to the lender's GRO. So, do you think in such cases, the GRO himself or herself can be the contact point for DPDP related queries or complaints? Or is there a requirement for a separate person to be appointed as the contact person? Aditya, if you could take up this query.
Right. This is a view I believe we've also expressed in our write-up, but the existing GRO can be the contact point for the purpose of redressal of grievances. The exception being in the case of significant data fiduciaries who are required to appoint a DPO for the purpose of the grievance redressal. So I think that would be our view on it.
Right. Are you saying that the DPO is needed separately, or are you saying that the GRO himself or herself can act as the business contact person?
This is just to reiterate what I've said. The existing GRO can be the contact point for the purpose of the redressal of grievances. But where you are required to appoint a DPO, then yes, in the case of significant data fiduciaries, for instance, which have not been notified. But of course, the Act does give certain criteria based on which they may be notified. Reference may be had to the Act for such purpose. In such case, yes, the DPO would have to be appointed for the purpose of grievance redressal.
Okay, I think that about covers it for grievance redressal. So moving on, uh, it is also important to discuss the rules towards nomination. So the DPDP Act brings this unique concept of nomination to the lending space. I mean, nomination not in respect of exercise of rights of security, but in terms of exercise of rights that are provided under the DPDP Act. So, do you think this will have any material impact on lenders? I mean, if so, what are the changes you think the lenders would be required to make, maybe in their loan documentation, maybe in their loan processes, to accommodate such a change?
So
Achishman, would you like to take?
yes, sir. So Shubhajit, in my view, see, usually nomination rights are commonly seen in insurance contracts where policyholders designate nominees. Such rights are typically usually absent in lending agreements. However, with the implementation of the DPDPA, this mandate has been created. So the lenders now specifically need to provide an option to the borrowers to nominate an individual in case of their death or incapacity itself. Uh, so in case of lending journey, as we all have discussed earlier also, given that the processing of personal data by lenders is generally based will in our view might should be generally based on the voluntary consent of borrowers. This provision in our view should be incorporated directly into the loan application form. uh, to ensure compliance and practicality, lenders should adopt an approach, in my view, similar to the ones used in insurance contracts, where the name of the borrower's name of the nominee, relationship with the borrower, and the contact details of the nominee can be provided in the loan application form itself. Through which, after the date of the DP, the nominee can exercise the DP's right on behalf of them, death or incapacity.
I think there are some questions on the YouTube live session. Maybe we can have a look at the questions first and try to answer them before we move on.
Yes, sure.
So
Or
the
else,
first question,
okay.
sorry, were you saying something, Aditya?
I was wondering whether we could actually also alternatively also do like go on to the session, maybe take all the questions towards the end, if we do have time for the same. Anything
Okay,
that
I think we can do that as well, but I think there are a few questions which are lined up. So
okay.
maybe we look at that so that we do not lose track of where, at which point in time or which point in the discussion the questions were raised.
Mhm.
So the first question is, in case the company does not have a website, how will it work? So I think this is about providing the link to the withdrawal of consent, to providing the details of the GR. So how would it work if the company does not have a website? Does the DPDP Act and the rules now bring in this additional compliance requirement of having a website, providing providing a link to the said information?
So Shubhajit, in if we refer to clause 3C of the rules, it specifically states that the in case where notice is the basis of processing of personal data, it specifically states that the communication link for accessing the website or app or both of such data fiduciary should be linked in the notice itself, through which the borrower can subsequently enforce their right of withdrawal. Further, there are other rules also which implicate upon a website being present. So, in my view, it would be the company, if it does not has a website, might need to formulate an operational website itself through which the DP can exercise its rights. Further, it should also be noted that since this the act itself is known as the Digital Personal Data Protection Act, it operates in the cyberspace itself. So it will always be prudent to have a website through which the DPs can raise their grievances or provide their consent or have a right of withdrawal through this. So I think requirement of a website becomes pretty evident from the act as well as the rules.
Just one more thing to add to what Ashishman
Sure,
said,
sure,
which
go
is
ahead. Arun.
why I believe we've been really emphasizing the need to read the act and the rules with the extant financial sector regulation, because they cannot be read in isolation. We extant financial sector regulation, the DL guidelines, since we're talking about the digital lending space, already require the RE to publish certain information on its website. So we are working on the assumption that you are in the digital lending space, you have a website, because if you didn't, you wouldn't be able to fulfill the other DL guidelines compliances, and as such, you can use that website for this purpose as well. At least that's the way I see it.
Right, Aditya. So what you are saying is there is already an assumption that the website would be available if a person is operating in the digital lending space.
Precisely. And if a website wasn't available, then it would actually be a red flag. Not just from the perspective of the act, but from also the perspective of other regulations, which do require disclosures, of policies, like links to certain portals and so on and so forth.
Right.
In fact, a website is a very integral part of the lending journey from the perspective of borrower rights, because it's an interface or connect the borrower has with the lender. Is also another way that I see it.
Okay. I think moving on to the next question. The next question is, if the borrower and co-borrower are involved in any deal, then two separate consents will be needed, or one consent from with signatures from both will suffice.
I think both of the co-borrower signatures would be required as an opt-in option. It will.
Because there are two data principles, so there should be separate and explicit consent from each of the data principles. We are going with the view that there should be separate consents that should be open. Is that the understanding?
Yeah, but
The
see,
case,
in the lending journey, it should also be noted that as we have pointed out also, when I am filling out a loan application form, I am actually voluntarily providing my details, and it is not a consent-based processing. It falls under the legitimate uses. So for other purposes, like if you want to cross-market any product or if you want to run analytics on that data, to that extent, a notice and a specific consent would be required. However, for other purposes, since the borrower itself is voluntarily subscribing to the loan and servicing of the loan, I do not think there should be an issue.
So now we have another question where it says when the consent was signed, there was X number of third parties involved. However, say over the next year, the list of third parties have changed. Then will another consent be needed? So this, I think, is delving into the issue of whether of sharing the data with third parties.
right.
So does the DPDP Act or the rules provide for any provision that third parties, the identity of third parties also need to be disclosed? Or if the third party changes, whether an updated consent form with the updated information also needs to be provided?
I, Archana, would you like to go first and take this
Yeah,
up?
sure. So, see, in my view, it is that if I am assuming these third parties are data processors and not data fiduciaries, in case these third parties are data processors and they are providing any service to me as a consequence of which they are required to process the data, the DPDP rules does not prescribe anything of a requirement of a consent, nor does it require the names of data processors being published. However, yeah, there is a right of access and I can know who is processing my data. And if that request is raised pursuant to that section of the act, then those details have to be provided. However, consent is not required. Now, moving on from the DPDP rules to the digital lending space. So the digital lending guidelines is itself highly focused on consent itself. Though the digital lending guidelines does not state that you need consent for processing by third parties. However, there is an explicit requirement of disclosing the names of the third parties who are going to process my information, and also a right in the DLA app. DLA needs to be provided to the data principal so that the data principal can restrict specific disclosure of data. In case the data principal exercise such a right, then ideally the third parties should not process that data, and maybe the data fiduciary can search for alternate third party.
Just one thing I would like to add. Is an addition possible right now, Shubhajit? Can I just
So go ahead.
highlight? Right. Just one addition would be, once again, to reiterate, we have to read the regulations together. Um, in case, the way I see it, in case there is, just to read the question again, when the consent was signed, there was an X number of third parties. However, we say that over the next year, the list of third parties have changed. It depends on what purpose the information is being shared with to the third parties. If it is for the, if let's say at the time of loan sanction, or let's say there was a notice given to the borrower saying that list data may be shared to third parties for the purpose of recovery function. At least is the way I see it. It's my personal view. For a recovery function, and you have already obtained consent for sharing data for the purpose of recovery function, and to that limited extent, the recovery function is an example, can be any other purpose also, but to the extent of the stated purpose there is a change in the list, then no. But if there is a whole other purpose, means and purpose of processing personal data that's emerging by sharing this to a third party, let's say for the purpose of cross selling or cross marketing, then yes, I believe consent would have to be procured. And the other thing would be from the perspective of DL guidelines. It's, I think, very clearly under para 10.4, which I can just read out verbatim. Explicit consent of the borrower shall be taken before sharing personal information with any third party, except for cases where such sharing is required as per statutory or regulatory requirement. So that's
Thank
how.
you, Aditya. That makes it very clear. So I think those were the questions posed on the YouTube live session. Moving back to our current Q&A, we were discussing the grievance redressal mechanism, and it was mentioned that the lenders have long been obligated to maintain confidentiality of borrower information and implement necessary measures to safeguard it. The rules and the act require the data fiduciary to have in place reasonable data safeguards. Could you please perhaps shed some light on what is understood by reasonable safeguards in this case? Aditya, if you would like to take this up.
Right. Um, for reasonable safeguards, you mentioned the act. I think it's very useful for our audience always have context of the act, because not everybody would be able to correlate it spontaneously unless you're really working in the space continuously. So Section 8 of the DPDPA states that the data fiduciary would be responsible for complying with the provisions of the act, irrespective of any agreement to the contrary or failure by the data principal. Um, Now, as we had expressed in our write-up, this means that the obligations cannot be contracted away, right? Further, Section 8 requires that the data fiduciary shall process the personal data under its controls by taking reasonable security safeguards to prevent personal data breach. What comes under this reasonable security safeguards is, let's say, delved into the rules. Now, under the rules, Rule 6 outlines the reasonable security safeguard that the data fiduciaries must implement to protect personal data. I can just list these out. and I can explain what these measures include. They include establishing appropriate controls to ensure access management for the lender's computer resources, monitoring and reviewing the visibility of personal data through access logs, aim to detect unauthorized access, remediate issues, and prevent recurrence, including provisions and contracts with the data processor to ensure that they take reasonable steps to protect data. And that's why we always keep talking about reading different regulations together, because I'm sure for those in the regulatory space, including provisions and contracts with data processors is something that they will recall is also captured under the outsourcing directions. Now, coming back here, including provisions and contracts with the data processors to ensure that they take reasonable steps. And then finally, implementing technical and organizational measures such as policies and SOPs to ensure effective adherence to security safeguards. Right? Now, for lenders, lenders are likely, this is like a perspective, the lenders are likely already in compliance with these requirements, provided that they are following the IT governance, IT outsourcing, or the IT outsourcing directions. Because these RBI guidelines already mandate many of these measures, like I just pointed out with the clauses to be captured in the contract, for instance. And in fact, what these regulations do is they don't just tell you that you have to have the clause, but they give you a very long list of um, sub clauses to include, like aspects that have to be captured in the contract. Um, so along, they also have additional requirements to protect information assets. Of course, there would be variances based on the asset size of the entity. So, like we said, it depends on like it depends on the extent to which you're following these directions, and the applicability of these directions also in many cases changes based on the asset size of the entity, or rather it depends on the asset size of the entity. So this aspect actually of how the asset size of the entity would influence this particular aspect has been detailed in our write-up. Now, one notable addition under the DPDP Act is the requirement for lenders to encrypt, obfuscate, mask, or tokenize personal data to further safeguard it. So I think you can say that largely the existing IT norms in the fintech space, in the digital lending space, and those under the DPDP Act align well. And at least in my view, they actually complement each other, because what is now emerging is a very robust data protection framework without creating duplicative or conflicting obligations. In my view, at least, they do lean into each other. So I think that would be the answer, Shubhajit.
Right, Aditya. Aditya, you highlighted the fact that there is a requirement to include provisions in contracts with data processor for taking reasonable security safeguards, right? This requirement of putting clauses in the contracts is pretty clear. But with respect to data processor, in your views, can lenders get away by merely providing such clauses in the forms of refs and warranties, or do you think that additional steps also need to be taken by the lender?
This is in the case of data processors.
This is in the case of contracts with data processors, yes.
Right. So under the IT outsourcing directions and financial services outsourcing and IT governance directions, lenders are required to conduct due diligence on vendors performing these activities on their behalf for them. So they're service providers. However, this due diligence process may not always include a comprehensive risk assessment focused on the borrower data or personal data confidentiality from the perspective of the regulation alone. So when Rule 6F of the rules and Section 8 of the Act are read together, it becomes quite clear that the data fiduciary must perform a vendor privacy risk assessment. Now, this assessment should evaluate the privacy architecture of the vendor systems, the processes, the technical, and the security standards. Failing to conduct such an assessment could result in penalties of up to 250 crores. And this actually, like the penalties, it once again highlights a very serious, the serious consequences that emerge from the non-compliance of this new regime. Now, given the scale of these potential penalties and the risks posed to borrower data relying solely on representations and warranties from vendors, as relying solely relying on these representations would, in our view, be insufficient. And that's also something we just substantiated by talking about Rule 6 and Section 8 of the Act. Because this approach actually overlooks the necessity of really assessing the vendor's practices. And that's something we mentioned even at the beginning of the video, that we are moving away from this tick box or checkbox compliance approach, where earlier it might have been feasible to say, okay, the regulation states this, I will put a clause in the contract to this effect, or I will comply with it to the bare minimum. And now there's a need to go much deeper and be more substantive with your practices. So I wouldn't want to stretch my answer too long, Shubhajit, but to fully comply with the law and mitigate the risks, the data fiduciary should conduct a vendor privacy risk assessment before onboarding any vendor handling personal data. Actually,
Right, right. And I think periodic audits you would also recommend it. I mean, having periodic audits over
absolutely,
the
absolutely,
tenure of the
absolutely,
contract.
absolutely,
Right.
yes.
But again, I mean, talking about reasonable safety, at least reasonable technical safeguards. I mean, no security system or standard is completely fooled. I mean, in case there is a data breach happens, I mean, it may compromise both proprietary data as well as personal data. So now, what I would like to ask is, the under the DPDPA, is the DF required to give data principals any notice of such data breach? And if yes, they have to give a notice. Is there any prescribed format? Does it have to be to individual data principals, or a blanket notice will suffice? So, Achishman, has there been any rules or prescriptions provided in this aspect?
Yeah, so firstly, answering the first part of the question, whether any rules have been prescribed towards this or not. Yes, Rule 7 of the DPDP provides the requirements when notifying the data principals as well as the data protection board towards any personal data breach. In respect of data principles, the rule stipulates that the data fiduciary, without delay, shall intimate the DP with a description of the breach, including its nature, extent, timing, and location of its occurrence, the consequences relevant to her that are likely to arise from the breach, the measures that the data fiduciary has implemented to mitigate such a risk, the safety measures that the data principal is required to take to protect his or her interest, as well as the business publishing providing a business contact information of a person who is capable of responding to those any queries that is raised by the data principal in relation to the personal data breach. As has been already stated by us above, this business contact person can easily be the existing GRO, except in cases of significant data fiduciaries where there would be a requirement of appointing a separate DPO to address these queries that are raised in relation to the personal data breach. Further, it should also be noted that a similar notification is required to be provided to the Data Protection Board also, whereunder initially during the intimation, the description of the breach, its nature, extent, timing, and location, and the likely impact that it might have on the data principals are required to be provided to the DPP. Further, there is also a requirement of follow-up intimation to be provided to the DPP within a period of 72 hours, or in case a longer time has been requested for complying with this request, the DPP may grant the same. However, the follow-up response required to be same to the DPP is basically an update on the security incident, that a personal data breach incident that has happened, which should state the broad facts related to the event, circumstances, the reasons leading to the breach, measures that have been implemented, if any, by the data fiduciary to mitigate such a breach, any findings upon who is the perpetrator or who has caused such a breach, and remedial measures that have been taken to prevent such recurrence of a breach in the future, along with also providing a report regarding the intimation that is given to the data principals.
You said immediate, right, Achishman? I mean, what do you mean by immediate notice?
Shubhajit, I would just like to clarify. I wanted to say without delay and not immediate. So the rule states that intimation requires to be provided to the data principal as well as the DPP without delay from the personal data breach incident. However, in my view, without delay does not mean an immediate intimation, and it should be ideally interpreted as soon as possible, considering that the primary purpose is not towards reporting, but to protect the borrower data from further getting leaked or breached, right? So this has also been provided. If you read Rule 7C of the DPDP rules, it also stipulates that when I am providing a breach notification to the data principal, the data fiduciary is required to provide in such a notification the measures that have been implemented. So if I am going by an immediate approach, obviously I won't be able to take any measures towards it. So ideally, I should first hand take some measures and go to the DP with a statement saying that, see, I have taken these measures and these are the measures that I am going to take for these are the measures I am going to take so on to prevent the loss of any of your further data. However, having said that, to avoid any scope of ambiguity, however, in my view, ideally the breach notification should be sent to the data principal within a period of 24 hours from the observation of the breach. While we are also under this context, it should also be pertinent to discuss an additional compliance requirement that is already required to be complied with by the data fiduciaries, that is reporting to certain. So basically, certain has a directive which states that any data breach that you observe, that is a general data breach, and personal data will obviously come under within its ambit. So you have to report to certain with the breach details within a period of 6 hours from the observance of such a breach.
Right. I mean, the reporting to certain is separate, but in terms of reporting to data principal, wouldn't notification in a widely circulated newspaper be sufficient for that purpose?
So Shubhajit, so Section 8.6, to answer this question, I would like to point out to Section 8.6 of the DPDP Act, which provides explicitly and mandates that each data principal must be individually notified in the event of a data breach. This essentially necessitates the data fiduciaries to implement mechanism to ensure that every data principal is properly intimated about such an incident. Rule 7 further clarifies this obligation, specifying that the data fiduciaries notice, that is breach notification, must notify each data principal in a concise, clear, and plain language about the breach through their user account or any other registered mode of communication. The rule further also defines user account broadly as include profiles, pages, an app, the website, etc., through which the data principal is able to access the services of the data fiduciary. Now, there will be a two-pronged discussion towards this in case of digital lending and in case of physical lending, how this breach notification is required to be provided. For example, in case of digital lending, breach notification can be directly sent to the user app, as had been also stated by Aditya, by my colleague Aditya in the previous slides, that it's basically an app-based registration, and the DP is capable of identifying who is actually to whom I am actually providing the service, and ideally the digital lending app itself can provide this notification through the DLA. For that, even in cases where this DLA is owned by a third party, that DLA can be used to provide this notification. Additionally, it would be my suggestion that if the lender also has an operational website, though that website might not be used for procuring borrowers, the breach notification should also be prominently displayed in the website, complementing the in-app notification. In case of physical lending, ideally this breach notification should be sent through registered email address or the mobile number that has been provided by the borrower during the loan application process.
Okay. I think we are at the hour mark. So that actually brings me to our final question before we move on to maybe any viewer questions that we may have. So in the digital lending guidelines, there is a clear requirement for data localization within India. Are there any such requirements also prescribed under the rules?
Data localization per se, that has not been dealt specifically under the rules. However, it has been stated that in case any personal data relating to any in relation to any subject in India, or any to basically not in subject in India, to which the DPDP rules applies to, cannot be transferred to such a country or a territorial jurisdiction that the central government has not by a general or special order specifically permitted. So during when the act came out, there was an ongoing suggestion, or might be called a rumor, that the DPDP, that the DPB or the central government may come out with a blacklist. However, we might have to wait to see how the actual approach regarding this notification of the countries will be handled by the relevant authorities.
Thank you so much, Achishman. I think there are no additional questions from the audience. We may have covered the topic very well, or we may have been rather obtuse with our answers, so we don't know which is which. However, this brings us to the end of the session because there is a need. I mean, we know there is a need, indeed a need to unpack these rules and the acts for the financial sector entities. We would likely be developing more resources on this specific aspect as time goes on. Anything Achishman or Aditya would like to add uh, as your ending comments? You may add. You both have about 30 seconds each. to provide your opinions.
Aditya, you may go first.
I would just say, please do stay tuned. Do stay tuned for more. And we thank you very, very much for attending the 13th edition of our Shastrartha series. I think the link to some of the resources is put up in the YouTube live comments. But you can also just look up DPDP rules, Vinod Kothari consultants, DPDP Act, Vinod Kothari consultants, consent managers for NBFCs, Vinod Kothari consultants, to see the existing resources we have on the same. But there is really a lot to develop in this area, and we would likely be coming out with something. So
Yeah. So from my end, there is nothing to top up what Aditya has sent and Subhojit sir has sent. I think this was a very interesting session for all three of us and our viewers. We hope that if we host more such sessions, we will get more viewers as such. And it is obviously interesting to talk about this ever emerging topic. And I will just head forward to Subhojit sir if any ending remarks from his end.
thank you so much.
No, I would just like to thank the both of you for providing such an enlightening session. Thank you for me. It has been a learning for me as well. Thank you so much,
Thank
both
you.
Aditya and Achishma. Thank you.
Thank you.
Both of you for providing such an enlightening session. Thank you for me. It has been a learning for me as well. Thank you so much,
Thank
both
you.
Aditya and Achishma. Thank you.
Thank you.
Both of you for providing such an enlightening session. Thank you for me. It has been a learning for me as well. Thank you so much,
Thank
both
you.
Aditya and Achishma. Thank you.
Thank you.
Recording stopped.
Both of you for providing such an enlightening session. Thank you.